I'm Vijay and you're watching Courts Roundup. In this program, we bring you the latest legal news and details of court proceedings. And before we begin, here's the headlines. Arnab Goswami gets interim bail from Supreme Court in abetment to suicide case. Supreme Court grants Arnab Goswami and two others interim bail. Says high courts are not doing enough in matters where personal liberty is denied. We are travelling to the path of destruction. Delhi High Court agrees to extend for 30 more days the interim bail granted to prisoners to decongest jails in the light of COVID-19 pandemic. The Bombay High Court granted permission to two Jain trusts to keep temples open during the 5 days of Diwali. Court demands regulating the entry of visitors. And the Allahabad High Court stays demolition of the house of Uttar Pradesh MLA Vijay Mishra. Mishra has challenged the demolition order, asking reasonable opportunity to contest it.
India Legal presents Courts Roundup.
And first up, Republic TV's Arnab Goswami has been granted bail by the Supreme Court in a 2018 abetment to suicide case. He and two others were arrested last week in connection with the suicide of architect Anve Nayak and his mother. A two-judge bench of Justices D.Y. Chandrachud and Indra Banerjee pulled up the Maharashtra government over the TV anchor's arrest as they heard the petition through video conferencing. The Supreme Court said Arnab Goswami must cooperate with the probe, and the court also said that the release of the three must not be delayed by 2 days and asked them to furnish bond of 50,000 rupees. The Supreme Court has expressed a strong displeasure over the Bombay High Court's order dismissing Republic TV editor-in-chief Arnab Goswami's bail plea in an abetment to suicide case and said high courts are not doing enough in matters where personal liberty is denied. And if a constitutional court don't interfere, we are travelling to a path of destruction, undeniably. The hearing comes 2 days after the Bombay High Court turned down Arnab Goswami's plea against his arrest and the reopening of the case. I do not watch the channel, Justice Chandrachud said and earlier, but asserted that if the Constitutional Court did not interfere, we are travelling the path of destruction undeniably. Goswami's lawyer, Harish Salve, had argued in the hearing, is Arnab Goswami a terrorist? Are there any murder charges on him? Why can't he be given bail? The court had some tough words for the Maharashtra government over the arrest last Wednesday of the TV anchor. According to the Mumbai police, Anve Nayak, who designed the sets of Republic TV, had left a suicide note blaming Mr. Goswami and two others for dues he alleged had not been paid to him. And earlier, the president of the Supreme Court Bar Association, Dushyant Dev, has written a letter to the Secretary General of the Supreme Court, strongly protesting against the extraordinary urgent listing of the special leave petition filed by Republic TV chief Arnab Goswami in connection to the 2018 abetment to suicide case. A vacation bench of Justices D.Y. Chandrachud and Indra Banerjee had decided to consider the petition of Goswami, who has been under custody since November 4th. In the case, Dev has written against selective listing of matters by the Supreme Court registry, especially during the pandemic, where thousands of citizens languish in jails due to non-listing of their matters for months, whereas an influential man's petition listed within a day. He wrote, "The serious issue here is selective The Supreme Court affirmed the Calcutta High Court order banning the sale and bursting of firecrackers during Diwali, Chhath Puja, Kali Puja, etc. in the entire state of West Bengal. A vacation bench of Justices D.Y. Chandrachud and Indira Banerjee dismissed the special leave petition filed against the November 5th order passed by a division bench of the High Court. In the brief hearing held on Monday, Justices Chandrachud observed that preservation of life was more important during COVID-19 pandemic than the celebration of festivals. The judge also told senior advocate Siddharth Bhatnagar that the counsel of the petitioner Gautam Roy, High Courts know the local situation better. Of course, festivals are more important in our culture, but we are in the middle of pandemic. There can be no greater value than the preservation of life. We understand this may involve hardship, but look at the COVID-19 affected people in the hospitals, elderly people, etc. Can anyone step out of the house in Calcutta, Delhi or any part of the city today? But Nagar submitted that the High Court had no empirical data to arrive at the conclusion regarding the necessity of the crackers ban. Justice Chandrachud disagreed with this view. Faced with the disinclination of the bench, Bhatnagar made an alternate submission, conceding to sustain the firecrackers ban for Diwali. Bhatnagar urged the bench to reconsider the ban during the other upcoming festivals like Durga Puja, Kali Puja, Chhath Puja, etc. Following this brief exchange, the bench said that it was dismissing the petition. And we are now joined by Advocate Divyanshi for more update on this.
Yes, in this matter, the Apex Court has affirmed the order given by Calcutta High Court, in which court has banned the sale and bursting of firecrackers during Diwali, Chhath Puja, Kali Puja, etc. in the entire state of West Bengal. Observing that, the bench has held, we understand these festivals are important, but when lives are at peril, any effort to save human life should be made. Court has further held that the local police should ensure that COVID protocol is maintained, including the distancing norms, and there must not be overcrowding within the temple precinct or outside.
Thank you, Divyanshi, for the update. And moving on, the Supreme Court has declined to lift the stay on Delhi government plan to reserve 80% of ICU beds in private hospitals for COVID-19 patients. The Apex Court has refused to lift stay on Delhi government plan on ICU beds. The top court has directed the High Court to hear the case on November 12 after Additional Solicitor General Sanjay Jain, appearing for Delhi government, stated that the COVID situation in the national capital was worsening with each passing day. The appeal filed through Advocate Chirag M. Shroff assailed the 22nd September order of a single judge of the High Court, which has stayed the government decision to reserve beds in private hospital for COVID patients. This order was passed by Justice Navin Chawla, a division bench order of the High Court, posting the hearing of the case for November 27th, without vacating the stay issued by the single judge, was also challenged before the Supreme Court. In its appeal, the Delhi government stated that High Court failed to consider that it only directed 33 private nursing homes and hospitals, out of which of almost 1170 private nursing homes and hospitals across NCT of Delhi to reserve 80% of their ICU beds for COVID-19 patients. However, the Supreme Court noted that the adjournment granted by the division bench was on request of Delhi government itself, and that any request to hear it early or to advance the hearing date could have been made before the concerned court. To this, ASG Sanjay Jain responded to the counsel appearing before the High Court had certain health issues. Justice B.R. Gavia further questioned Jain on why no material was placed on record to show that there were no beds available for COVID-19 patients. Jain said that upcoming season of Diwali and pollution would create a spike in Delhi COVID caseload. However, the bench was unimpressed, stating that it is up to the Delhi High Court to hear and dispose of the case. The Delhi government in its plea had stated that none of 33 hospitals in question objected to the government order on reservation of hospital beds.
It also stated that the claim made by Association of Healthcare Providers petitioner before the Delhi High Court that adverse impact would be caused to non-COVID patients was simply to mask the commercial interest of private hospitals, who had been directed to only charge a capped fee for treatment of COVID-19 patients. The Supreme Court therefore directed the matter to be listed on November 12 before the concerned bench of the High Court. Bureau Report.
And the Supreme Court has ordered that no unnecessary adjournment should be granted in criminal cases pending against legislators across the country. The court said that the Witness Protection Scheme 2018 should be enforced by the concerned courts, and it also reiterated the earlier direction issued on September 16 regarding vacation of stay that may have been granted by the high courts. The court clarified that these directions are applicable to cases involving both sitting as well as former legislators. The court noted the report submitted by various high court and the report submitted by the amicus curiae. Some suggestion by the amicus curiae are for number one, for the efficacious disposal of these cases, robust video conferencing facilities and upgradation of infrastructure is necessary. Number two, the tenure of judicial officers dealing with the aforesaid cases is at least 2 years in order to ensure continuity. And the court as of now issued the following directives. Number one, keeping in mind the public interest involved in this matter and in order to prevent undue delay, we direct that no unnecessary adjournment be granted in these matters. Number two, at the cost of repetition, it is clarified that the direction in the present writ proceedings are applicable to both sitting as well as former legislators. The court also directed the High Court of Kerala to furnish a list of cases to the Chief Secretary, Director General of Police, where the warrant are not being executed. And Delhi High Court has agreed to extend for 30 more days the interim bail granted to prisoners to decongest jails in light of COVID-19 pandemic. The division bench of Justice Siddharth Mridul and Justice Talwant Singh extended such interim bail after taking into consideration the recommendation of the High Power Committee set to decongest prisoners in light of COVID-19. Earlier, the special bench of the Delhi High Court had ended the blanket order on extension of COVID-19 bails and had asked of all the prisoners to surrender in the phased manner. However, this decision was later stayed by the Supreme Court in a petition moved by the National Prison Research Forum. Both the Delhi government and the Director General prisoners showed no objection to extension of such set of bail for 30 more days. Additionally, the DG prisoner is directed to ensure that this order is conveyed to all the 3,337 UTPs by telephone as well as through all other available modes. And the National Company Law Tribunal Ahmedabad bench has directed ArcelorMittal India, the successful resolution applicant of Essar Steel, to pay CIRP cost of almost 1,300 crore rupees to Odisha slurry pipeline infrastructure. ArcelorMittal has been directed to pay the CIRP cost by December 15 this year. The order was passed by 2 members bench of M.B. Goswami, member judicial, and K.V. Gupta, member technical, in an application moved by Shrey Infrastructure Finance Limited, a financial creditor of the Odisha Slurry Pipeline Infrastructure Limited. In this application under Section 33(3) and 33(4), read with Section 65 IBC, Shrey Infrastructure Finance Limited applicant contended that ArcelorMittal contravened the resolution plan for Essar Steel when it failed to pay the right to use charges to the Odisha Slurry Pipeline Infrastructure Limited for its pipeline asset. This uses charges were hypothecated to the applicant by Odisha Slurry Pipeline Infrastructure Limited. The applicant inter alia submitted and that the right to use charges payable for the use of the pipeline belonging to OSPIL during the CIRP of Essar Steel constituted as CIRP cost within the meaning of Section 5(3) CIBC. ArcelorMittal, on the other hand, stated that after the approval of OSPIL resolution plan by Educating Authority and its subsequent implementation, the applicant had no locus to file the present application as a financial creditor of OSPIL. It inter alia was argued that insolvency resolution proceeding were for rehabilitation of a corporate debitor and were not in the nature of recovery proceedings. The Allahabad High Court has stayed the demolition of the house of Uttar Pradesh MLA Vijay Mishra. The MLA had filed a writ petition with the court challenging the demolition and saying that the demolition started 15 minutes after the court order on November 5th without giving him a reasonable opportunity to contest it. The court has asked the state authorities to file a counter affidavit within 2 weeks. The complainant has alleged that the authorities are behaving in a high-handed manner. The court has also directed the respondents to specifically disclose as to why a reasonable opportunity of the contest was denied to the petitioner. The court order said, till then, no further demolition shall be carried out by the authorities concerned. It will be open for the petitioner to remove their belongings from the house in question. The matter is listed for next hearing on December 2nd. This order has been given by Justice Ashwini Kumar Mishra on the petition of Indra Kali and others. The petitioner advocate Lokesh Kumar Dwivedi said that demolition was ordered on November 5th this year. The demolition operation commenced within 15 minutes. It was also stated that the house are in the names of both the petitioner, but the Prayagraj Development Authority had given notice to only one. It was contended that the sanction was obtained from the Development Authority for construction by the previous owner on February 3rd, 1980. And the petitioner also removed such construction that were in excess or contrary to the blueprint. The MLA claims that those prayers were ignored. To remain physically contactless in the Jain temples in one of the primary code of conduct since ages and in time because of pandemic. The Karnataka High Court refused to interfere in an ongoing police investigation and quash FIR filed against the managing director of Power TV and Kannada TV channel, Rakesh Shetty, for alleged extortion. The bench of Justice Suraj Govindaraj was hearing the plea of Power TV Managing Director Rakesh Shetty seeking quashing of the complaint and FIR. In the FIR, it was alleged that the petitioner news channel Power TV has been running a program with regard to the allegations of corruption and illegal financial dealings as well as interference in the day-to-day administration of the state government by the family members of present Chief Minister B.S. Yediyurappa. Further, it was alleged that the first telecast of the program by Power TV was aired containing a 3-minute alleged audio conversation between B.S. Vijendra, son of B.S. Yediyurappa, and a reporter of Power TV. Further, it was alleged that an audio clipping was put out in the public domain for the consumption of the people of the state. The counsel of the petitioner argued before the court that the complaint which has been filed is motivated, and it is also argued that the complaint was filed on account of political vendetta. And it is only in order to stifle the voice of the free press that the present complaint has been filed, since the news reported by the channel was unpalatable to the Chief Minister and his family. The Madras High Court has ordered authorities to block the derogatory remark made by former High Court Judge Justice C.S. Karnan on social media platform, observing that the damage caused would be incalculable if derogatory remarks continue to be uploaded online. After hearing preliminary submission made by senior advocate S. Prabhakaran, a bench of justices Satyanarayan and R. Hemalata allowed the interim relief prayed for by the petitioner Tamil Nadu Bar Council. In its petition, the State Bar Council has sought criminal and legal action against a former judge and has also prayed for an interim direction to block the URL of website hosted by Facebook, YouTube and Google, which has shared the ill content and video featuring Karnan derogatory remarks. The bench observed on Monday that the allegation being made by Karnan were prima facie highly defamatory. In the course of the order, the High Court also stated that this is rather unfortunate to note that Justice C.S. Karnan, who had held an important constitutional post, had gone down to such a level and repeatedly scandalized and made vituperative, obscene and unparliamentary attacks against judges of the Supreme Court, the High Court and their families. The court further noted that his tirade continued unabated, with allegations being made against female staff of the court and women lawyers as well, including a designated senior advocate. Well, that's all for Courts Roundup. Thank you for tuning in.
India Legal presents Courts Roundup.